censorship from either Twitter, Facebook, LinkedIn, sometimes all the above.
60 degrees off the government's position, still, you're out.
I think the platforms are victims here, forced to do this by government pressure.
And I wouldn't have thought that at the very beginning.
Government's position was essentially, we are only persuading them until we break their will.
All these platforms and who was making them up, they don't seem to want to do it.
That made the government really mad, and almost immediately you have Jen Psaki saying we favor a robust antitrust program.
Good afternoon, everyone. I'm John Vecchione, Senior Litigation Counsel here at the New Civil Liberties Alliance, and I'm welcome to the New Civil Liberties Alliance, and today's Luncheon Law program is entitled What Missouri versus Biden Means for Free Speech. And I'm delighted that our guests today are well versed in this subject. To my immediate left is Zhonette Brown, also Senior Litigation Counsel here at New Civil Liberties Alliance, and we represent certain individual plaintiffs that you'll hear about today in the case of Missouri v. Biden. And we're thrilled to have John Sauer, a principal at James Otis Law Group, LLC. He originally represented Missouri in the case and now represents Louisiana. He previously served as Deputy Attorney General for Special Litigation for Missouri. And he has, I think it's fair to say, has taken maybe the heaviest of the laboring oars in this litigation. So we're thrilled to have him.
Great to be here.
And so I'll start with you, John. I just, we'll get to what's happened, but why did Missouri and Louisiana file this case?
That's a great question. This case was, in many ways, a labor of love for me and some of the attorneys that were then in the Missouri Attorney General's office. When we started working on it in early 2022, we started researching and drafting the complaint in the case. And at that time, there was a great deal of public evidence of viewpoint-based discrimination in the what we call censorship practices. They call it content moderation, which is a kind of, Orwellian euphemism for censorship. But in the censorship practices of virtually every major social media platform, combined with it, which in itself, because they're private companies, may not in itself raise First Amendment issues under certain circumstances it may, as we see here. But there was also a great deal of just public evidence that had come out over 2021 and 2022 of the direct involvement of the federal government, federal officials, and federal agencies in influencing those censorship efforts. I mean, in many ways, some of the most striking examples of those were public statements that Jen Psaki had made as the White House Communications Director, right there from the podium, famously saying in the summer of 2022, quote, "We're flagging problematic posts for Facebook." And then there was a series of also threatening statements made by the White House especially during that COVID year of 2021, suggesting that if the platforms don't fall into line and censor the viewpoints that we dislike, then there's going to be adverse legal consequences to them. So Ms. Psaki herself had made multiple statements to that effect, both in May of 2021, July of 2021, April of 2022, February of 2022. Also, the White House Communications Director Bedingfield had made similar statements on July 20th of 2022. Plus, there's all kinds of statements in the background from their political allies in Congress who've been hammering this. So if you look at it together, what we saw was a huge problem, right? A huge problem for the freedom of expression, even if it's not a First Amendment problem, which is that certain viewpoints had been rendered like unspeakable, inexpressible on social media. And some of these were very, very valid viewpoints. We're not talking about just crank viewpoints or obviously false statements, but in many cases, compelling, importantly, truthful statements. Things like, as we now know, based on our evidence, the suppression of the Hunter Biden laptop story, which we all now know was thoroughly researched, thoroughly sourced, and accurate reporting on something of immense consequence shortly before a presidential election.
And it appears the FBI knew it at the time.
Yes, we now have factual findings to that effect from our district judge based on evidence that includes a lengthy 7-hour deposition of a FBI agent who was right in the weeds of those issues. So if you look at the big picture, why do we do it? We saw a huge problem for the freedom of expression, and we saw the direct involvement, lots of public evidence of the direct involvement of federal officials in that. Certain lawsuits were ahead of us. NCLA's own lawsuit in the Changizi matter was already ahead.
Because you called us. Tell us, how did you get us involved?
Yeah, that's a great question. We had brought it on behalf of 2 states, but we always thought it was a more forceful case if private plaintiffs were involved. And we had recruited a bunch of private speakers who experienced censorship on social media to file declarations in support of a motion for a preliminary injunction, which was filed way back, in June of 2022. Some of those declarants were NCLA's own clients, and I had no prior relationship with NCLA, but I had reached out to a different public interest group that, with people who I know really well, and said, you guys want to get involved in this? And they had said, no, we think it's really interesting, but it's really outside of our lane. However, you should definitely talk to NCLA because that's right up their alley. And in fact, I was familiar with the Changizi litigation already, so it was kind of a natural thing for me to reach out to you guys and say, hey, do you want to jump in here as the lawyers for the private plaintiffs who've contributed just a smashing amount of important stuff to the case?
Right, and so we did then join. We have our clients. Why don't you tell the audience who our clients are and what their problem is?
Sure. So NCLA has the fortune of representing Dr. Jay Bhattacharya. He was professor at Stanford and one of the co-authors of the Great Barrington Declaration, which I'll explain a little bit more in a minute. His co-author, or one of his co-authors, was Dr. Martin Kulldorff. And the Great Barrington Declaration essentially questioned the validity and utility of having unaccepted lockdowns without exceptions. They advocated for focused protection. And so they started off just from their expertise as epidemiologists, stats, biostats professors. They have hundreds of published articles. And so they issued that and engaged in some other public conversation, a roundtable with Governor DeSantis, et cetera. We also represent Dr. Aaron Kheriaty, who was a bioethicist at the University of California, Irvine, who was providing opinions to the university and publicly about the ethics of what was happening in response to COVID-19, and ultimately was fired for his position that it was inappropriate to require people who had natural immunity to become vaccinated against COVID-19. We also represent Jill Hines. Jill is in Louisiana. She is the co-director of Health Freedom Louisiana, a group that promotes freedom of choice in health decisions that people make individually and their right to make those choices individually. Every one of those plaintiffs experienced censorship from either Twitter, Facebook, LinkedIn, sometimes all the above, having their content shadow banned, fact checked, having the number of supporters throttled, all sorts of ways, having their speech that opposed the government's priorities regulated or dialed back.
And I'd like to point out, as John was saying, much of this, some of it was opinion, but much of it was just factual. One of the things that I'm always struck by in the COVID and the COVID area and the vaccine area is that our laws require, the FDA requires to have a drug in this country, you have to put all the side effects on the label. It's a law, that's what they have to do. But if you were tweeting out what the side effects were with the vaccines, they're the admitted side effects. Every drug has them. They're on that's why the commercials on TV are so long at the end while they tell you what they are. They all have them, but you would get shadow banned for putting that kind of truthful stuff up there. But John, I want to let you go on because you did mention the Hunter laptop. We have been more involved in the COVID and the vaccine area where people who disagreed or even had just 60 degrees off the government's position, still, you're out. What were some of the other issues that you saw banned?
Well, there's a great range of conduct. So the allegations in the initial complaint, and most of the complaints have focused on two big areas. So there's the COVID area where the censorship was extraordinary and it targeted truthful content. So what you actually see in our evidence is the kind of crank views on COVID, like there's a microchip in the vaccine that floats in your bloodstream. That was kind of censored at the CDC level. It was Carol Crawford who was saying, hey, guys, this is bad, take that down. But sort of sweeping what they call borderline content, what the White House really wanted was the truthful content taken down. So you see the emails from the White House saying, to the platforms, borderline content is truthful content that the government believes could be taken out of context to promote vaccine hesitancy in this context. And the platforms recognize this. They talk about borderline content all the time. So you have emails from the White House that say things like, hey, how are you censoring people expressing their opposition to vaccination in terms of personal and civil liberties? Or people telling truthful but very sensational anecdotes of having a bad experience with the vaccine. What the White House really wanted to silence was truthful speech about the vaccine that might contradict its preferred narratives on it, because of course that's the most effective speech, the most persuasive speech. It was really aggressive viewpoint discrimination. So in the COVID area, there was very, very aggressive censorship, and there was a very extensive involvement, direct involvement of the White House in that area. The other area that our allegations principally focus on is election-related speech. Speech about election integrity, speech about topics like is voting by mail a secure method of voting, things in that area, in that lane. There, what we see is involvement of congressional staffers in federal agencies going all the way back to at least 2018. We have a finding to that effect that pressure campaign to get the platforms to kind of crack down on the election-related, what they call misinformation. And worst of all is to tie into what you said, malinformation. Misinformation is what the government thinks is false. Disinformation is what the government thinks is false, and when the government thinks you're deliberately spreading false information. Malinformation is the information that the government admits is true, but the government thinks is not provided with the proper context to allow people to draw the right conclusions from it. So they invented a whole new word, malinformation, to justify going after the censorship of truthful speech and ideas. And you see this in the election integrity context as well. I mean, obviously I mentioned the Hunter Biden laptop story because there's been so much news around that, but we actually see as a whole bunch of, really a whole censorship apparatus that was set up to police this. Because in the election context was where they started with the intersection with the private entities. So what you see is the federal officials in 2020 meeting carefully with officials at the Stanford Internet Observatory, University of Washington, Graphica, and setting up this enormous mass surveillance apparatus where you have these team of 120 analysts at these kind of non-governmental agencies that are working closely with the government and working closely with the platforms to review in real time literally hundreds of millions of social media postings and to flag them. That starts out in the election-related speech context, which again is about as core political speech can be. Speech about elections, and are elections secure, are elections safe? A great question that Judge Doty asked when we were there on May 26th to argue in front of them. He asked the government, is this statement protected by the First Amendment? The 2020 election was stolen.
And they couldn't answer it.
They would not concede that is protected by the First Amendment. He was at the bench like, you gotta be kidding me, right? And they were like, well, what if it's said by a Russian agent? He's like, no, that's not my hypothetical, right? Suppose an American citizen posts on social media, I think the 2020 election is stolen. People have a wide range of views about that. And in our country, the government doesn't decide the truth of that. But under what the federal government is doing, it has been. But another point we've been making is we focused on those two areas in our allegations, but what our evidence shows is an ongoing expansion of what we've called the federal censorship enterprise, and the Twitter Files journalists.
And just mention, it's whole of government. They say it's whole of government. And what does that mean?
Yeah, one of my favorite quotes is from Secretary Mayorkas, who in August of 2021 was talking about anti-disinformation efforts. And he says, we're pursuing this, quote, across the federal enterprise. That's where I got that word, which we use in our briefs. Because he said, there you have it from the Department of Homeland Security Secretary saying we're fighting misinformation across the federal enterprise. And as we now know, that statement was contemporaneous with the internal memoranda to set up the Disinformation Governance Board and the Nita Jenkins thing, which ended up being a big fiasco for them, but ended up being great for people who believe in freedom because it focused a lot of public attention on something that in some cases it's hard to get the public to focus on.
And I think that they were already doing, right? They set up the Disinformation Board, but they were already, they already had it, but not a name and a staff.
Yeah, it was already happening. It just wasn't as organized as they wanted it to be because it was so spread out across the entire breadth of the government. So they wanted a central switchboard to run this through so that different departments weren't giving the social media companies conflicting information. And because the volume was so huge, with all the departments and so many people, it's not like it was just the head of a department or one person in any given department. It was so many of the departments.
Or an occasional call.
Right, and they would call and then follow up with the call and follow up on the follow-up call. So they created this to manage what they were already doing.
And so that, I know we have some lawyers in the audience, to give you some idea of, so what happened is John filed a preliminary injunction, and then the court gave us discovery. And before we get to the preliminary injunction, which is going to be the main focus of this and what's going on, why don't you give the audience some idea of what discovery we were allowed, and from both the social media folks and then also from the government?
Yeah, that's a great question. And I had three jaw-dropping moments in the course of this litigation. One of them was a moment of great excitement. We filed a motion for a preliminary injunction back in June 14th of 2022. And I asked the judge for a kind of two-phase, a preliminary injunction to say, stop them from doing this, and then give us discovery. Because we're really basing it heavily on public reports and a handful of public statements, but we know they're emailing each other, they're talking on the phone, they're having meetings, and we want to know what's being said in those meetings. And we asked for a narrow scope of preliminary injunction to discovery, just the external communications between federal officials and 5 major social media platforms about misinformation, disinformation, and content moderation. That was our ask. He actually didn't grant us our preliminary injunction. But he granted us preliminary injunction related discovery on July 12th. I remember sitting at my desk and I see that order came in. And I was like, we got discovery. Because, of course, the problem had been there had been a lot of cases filed already, including by NCLA, and the judges had dismissed them all under Iqbal and Twombly. I passionately disagree with those rulings. I think those rulings were completely wrong, and that's as far as
I can imagine how I feel.
Right, exactly. Yeah, I mean, and these opinions, I'm like, you got to be kidding me. This obviously passes. These people should have gotten to discovery. But what made our case unique was the first case to actually get that discovery and see what they were actually saying to each other in private. And that one led to jaw-dropping moment number 2, their initial document production. We said, hey, we only got discovery against, we had only named about 6 agencies at that time, and we only got discovery against a handful of key custodians at each agency. And all we're getting is your external emails with social media platforms about censorship. Right? And what did we get? 18,000 pages in the first. I was like, oh my gosh. And I'm like, this goes way beyond. So we amended the complaint. We had 67 defendants instead of 15. And we had all these allegations that went on. We had a couple snapshots of this. There were some FOIA documents from the CDC that were released earlier where the BOLO emails are already out there. I was like, oh my gosh. There's stuff.
Be on the lookout.
Yeah.
BOLO memos, they're be on the lookout where the government told the social agencies, here's the stuff we really want to censor.
So that was the second big kind of oh wow, this went way beyond what we did. I thought this was bad going in, and it exceeded even my highly pessimistic expectations. Then we had a third moment, and the third moment came when we got the initial response from the platforms. We had a big fight with the platforms because we served them all with third-party subpoenas. And the platform said, you can't go to us first, you have to go to the parties first. We're a third party, so you've got to exhaust your attempts with the government before you come to us. And the government said, no, we're the White House and the government. We're the producer of last resort. You've got to go to the platforms first. So you had this weird triangulation, and we were trying to get it forward. What we ended up with was an agreement with the platforms to produce certain narrow classes of documents, and most importantly, just to identify the names. Who in the federal government is communicating with you? And we got that email, the first email from Facebook. I remember it distinctly because I was outside my house. It was a Monday, it was a federal holiday. And I was like, oh my gosh, 35 names. And they followed up the next week with another 13 names, 12 or 13 names, 47
and more
names.
than the government had given us.
Yes, and a whole bunch of names I'd never seen before, even though supposedly, a month earlier I'd gotten all the emails relevant to these people. And that was astonishing. And that just grew and grew and grew until we got a supplemental production from Twitter. Twitter initially said, 11, here's 11 officials that talked to us about censorship. And after Twitter's ownership change, we went back to them and said politely, hey, we think you guys understated this a tad. Can you update your list? 86 names. 11. I don't know how that has happened. When James Baker, the former FBI general counsel, was the general counsel on Twitter, they magically could only discover 11. And under new management, they said, well, it's going to be really hard for us because all of our records are, all over the place. And
we're just getting involved.
Yeah, but we were able to find 86 names for you in a couple of weeks. So the scope of it was astonishing.
Yeah, and I think I really want to emphasize this because it's not like we filed that John filed this and then we filed it and then joined this case in Louisiana. We didn't have a sort of rosy view of what was going on. But I don't think, and Janine Eunice used to be here and started many of these cases, even she was shocked. We were all stunned by it. And I think, Zhonette, you joined in and you've seen it. And did it match your prior views of what was going on, or was it greater?
Oh, it was far greater than what I would have expected. I came to public interest law with the idea that, there's some funny things going on with what the government's doing. We should be taking a look. But it's far beyond the scope of what people realize. And there was a lot of public information, but there's a reason that you get discovery, and discovery is so important. And with that discovery, you could really see the depth, breadth, the length in terms of how long it had gone back and how long it was going on.
And as I often say, this started under the Trump administration. It's like it's the administrative state doing this at all times. It really is. But I want to. So I guess so. We had agreements with the social media companies to turn over certain documents, and we never really forced them. We never went to court, and there was no motions.
There was extensive deliberation, but as it happened so far, there's been no motions to enforce against the platforms.
And so
could happen sometime.
It could happen sometime, exactly. But by and large, we got so much stuff. It was like a fire hose, really, just from that. And then the other thing we got, which I think was vital to this, is we got a limited number of depositions. And so we actually were able to take depositions of the government officials. Why don't you tell, who did we depose and why? Why do we pick those guys?
We asked for, it asked for 8 depositions initially, and we got shaved down by the Court of Appeals to 6. But
they knocked out Psaki, kind of.
Yeah, the government went on motions, and there was litigation at Fifth Circuit where we got kind of non-dispositive rulings, staying certain depositions, and we ended up moving forward. I didn't want to get bogged down, but the deposition, we ended up with 6 depositions. So in the order, they were Daniel Kimmage of the Global Engagement Center at the State Department, Carol Crawford of the CDC. The one John took that deposition. That was a quite eye-opening one, I thought, and I'm sure you thought the same, sitting in the chair. Elvis Chan of the FBI, who was kind of the point of contact between the social media platforms and the FBI and its Foreign Influence Task Force, which is heavily involved in this. Eric Waldo, who was the Chief Communications Officer of the Office of Surgeon General. Brian Scully of CISA, and Dr. Fauci.
And CISA is?
CISA is the Cybersecurity and Infrastructure Security Agency within the Department of Homeland Security. It's a sub-agency within the Department of Homeland Security, and we've described it as being kind of at the nerve center of the federal censorship. And then we had an order for the deposition of Rob Flaherty within the White House, and we accepted in lieu of that. The government had until then produced no documents at all directly from the White House, very limited White House communications, and that deposition was stayed, and we went to the judge, and as a kind of compromise early on that, we got his emails, but not his deposition, and those emails were just... that was like jaw-dropping moment number 4. The stuff he was saying in his emails and social media platforms ought to make anyone who cares about freedom of expression horrified.
And they're threatening. They're really threatening, bullying emails to such an extent that I always you can't imagine this whole idea that they were, because now that the government has just filed, we'll get to it, but the government has just filed a new brief how there's a very sharp line between coercion and persuasion. Well, these emails are not persuasive, but they are coercive. So I'm sure we'll be hearing more about it. But now it's sort of taken. I wanted to give the audience an idea of what we got, and I think we've done that. But now, eventually, on July 4th, Judge Doughty comes out with his injunction and a 155-page memorandum, which we will not go through. I'm just going to tell you.
Fascinating reading, though.
Yeah.
Publicly available.
Fascinating reading, but I want to focus first on the order itself. So, Zhonette, what did he order the government to do?
It's more what he ordered the government not to do. He ordered the government not to take actions to delete, suppress, or otherwise interfere with First Amendment protected speech. And because of the breadth of behavior that we had proved through hundreds of pages of proposed findings of fact, documents, testimony, he was specific in terms of saying no bolos, for instance. None of these meetings that they were having. You can't do switchboarding, which is another thing that they were doing.
Explain that.
Switchboarding is, again, it was a form of coordinating the communication of switchboarding in that context, particularly related to the election speech, and moderating anything that the government, the agencies felt was interfering with their viewpoint of election integrity, security, et cetera. But the judge took our allegations and the ordered tracks. You shouldn't email the social media companies. You shouldn't meet with them. You shouldn't collaborate with them. You shouldn't meet with these specific individuals or organizations too. And in each instance, it says, reduce, suppress, or otherwise interfere with speech, essentially. And that's a paraphrase, but that's essentially what it says. It says, remove, delete, suppress, or reduce First Amendment protected speech. And so he was very, very explicit, having those orders track what had been proven. And then he was careful also, because obviously the government was wildly opposed to having its viewpoint moderated in any way. And the judge was careful not to do that. He was careful in his order to have carve-outs. He said, the government is still allowed to, for instance, contact social media companies about criminal activity, about activity that interferes with the place or manner of an election.
Foreign interference.
Even other interference,
right.
Specifically with the method of an election. And he specifically had a carve out for government speech. So long as the government is promoting affirmatively what it wants to say, that's fine. So long as the government is not trying to reduce and delete and suppress the viewpoints that it disagrees with, it's fine. It's not going to violate this order.
And the other thing is, you don't really, when you're a judge and you write an injunction, you don't have to say what they can do. But he really did go through it here to kind of calm them down, because they really set their hair on fire that this was going to ruin their lives. The government was very, very upset, and
they're still upset.
And they're still upset. But I did think that was not necessary for the judge to do, but they did it. And John, now I'm going to. So all that discovery you already talked about. You've talked about a lot of it, but the judge then took it and said, "This is coercion." What in the memorandum struck you about why this is coercion and not persuasion?
Yes, and honestly, what I thought was incredibly powerful about the memorandum is the detail and extent of the factual findings. 82 pages, 577 citations of the record evidence. And we got an emergency stay motion from them. One of the points we made in our response is, the standard here is clearly erroneous, right? The district court has to be making a clearly erroneous factual finding for that not to be true. And he found, and the government didn't argue that as far as I could tell, didn't argue that a single factual finding was clearly erroneous. Those are the facts. One of the reasons they're not arguing that is because they're supported by the evidence, right? I mean, we have extensive evidence. That's why the discovery was so powerful in this case. So those are the facts of this case. That is going to be the record on appeal. I haven't read the brief they filed late last night yet. Their opening brief. Now they may get into some more factual disputes there, but we've got evidence. Those findings are not going to be clearly erroneous. They are good, solid, factual findings because that stuff happened. The emails that he quotes, it said that in the emails. And what you see there is at least two really powerfully coercive courses of communication. So one is engaged with principally by officials in the White House and the Surgeon General's office acting together. They're on the same meetings or the same phone calls. They're on the same emails with the platforms. And that has at least two elements to it. There is a long-standing private line of communication starting from literally the third day of the administration when Courtney Rowe emails Twitter and says, here's a tweet by RFK Jr. about the death of Hank Aaron after taking a vaccine that we don't like. Please take it down ASAP and be on the lookout for other tweets like this to take down. So it starts right away. And frankly, it almost certainly goes back to the transition. We don't have a discovery on that, but it goes back. But they're right away. They're hitting the ground running. That relentless pressure in private does not end, and that's got a whole bunch of badgering communications. There's an email that includes the F-bomb.
And badgering is a good word, because that is it. It just keeps going. And now Flaherty, he uses profanity and he does all this. It's really something. But everybody else is just badgering.
Exactly, yes. And so there's private pressure communication, and when they're not getting what you actually see in the COVID space is really Twitter and YouTube kind of falling down or rolling over early and playing ball with the administration. But Facebook, for some reason, they targeted Facebook as the problem actor, and we're going to put a special pressure on you. So you see, now Twitter did hold out. I mean, they were saying to Twitter, you got to deplatform Alex Berenson. So keep in mind, we're talking not just about, hey, take down misinformation, take down stuff that says this, but this particular speaker that we don't like, Alex Berenson, the disinformation dozen, 12 specific people, deplatform them now. That's the message from the White House. And it's interspersed with public threats. Right? So when they're not getting what they want, then all of a sudden Jen Psaki appears at the podium and she says, we think that the platforms have a duty to take down the misinformation, the disfavored viewpoints that we don't like. And by the way, very next sentence, the president supports a robust antitrust program for the platforms. So that's like, hey, the president thinks you should pay your protection money, and if you don't, he supports a kneecap injury program for you. Right? I mean, that's what it's like.
Section 230 is what they're referring to.
And you have that multiple times, right? So there's two really big common pressure points they put in the platforms. One is the threat to amend or repeal Section 230 immunity of the Communications Decency Act. That's something that commentators and our evidence describe as a hidden subsidy worth billions of dollars. So we're going to take away a multi-billion-dollar benefit if you don't do what we want. And then the other one is we're coming after you with antitrust enforcement, which is interesting because that's within the exclusive control of the administration. Does not need Congress to act because AG Garland can just say, have the antitrust division go after these people. And Mark Zuckerberg has publicly stated antitrust liability is an existential threat to the platforms because they are these big oligopolistic, entities. So that you have these public threats by the White House reinforcing the private badgering and the private pressure campaign with the White House working closely with the Surgeon General's office and other agencies.
And there's
Go
ahead.
Well, but the government, their position is, no, the court shouldn't look at the total picture. The reason that this isn't coercion from the government's point of view is because you just look at what one person said at one point in time, and then you look at what a different person said at a different point in time. And any one of those single acts is not coercion. And if a threat is made by someone and then followed up on by someone else, that's not coercion either. If you take everything down to its minimalist possible particle, then it's not coercion.
And it's a highly ironic argument because they also accused us of taking evidence out of context. I'm like, here's your context, guys, right? Flaherty is emailing you every other day using the F word to tell you to do this. And
they're very Rahm Emanuel type emails, the way I would put it if you've been here a long time.
But and that's, to tie back to your original question, that's just one of the pressure campaigns because there's a related, but in many ways, additional pressure campaign that goes back much further. Starting at least in 2017, according to the deposition of Elvis Chan, senior federal officials, including senior congressional staffers on the Intelligence Committee, SISI and HIPSI, right? Senate Select Committee on Intelligence, they call it SISI, House Permanent Select Committee on Intelligence, they call it HIPSI or HIPSI. And senior congressional staffers are flying out to Silicon Valley on an annual basis to meet directly with senior executives at the platforms. And in those meetings, they're showing them adverse proposed legislation, saying this is what we're going to pass if you don't come to the line and take down the disinformation. This is all election-related, election disinformation that we don't like. That goes back to 2017. Now, in that time, it's cloaked in the justification of, well, we just don't want foreign influence in elections because, everyone said there was all this foreign influence in the 2016 election, so we got to get this all taken down. But what you see is that foreign, keeping the foreigners out of our social media platforms, that justification falls away so fast, right? Especially in 2020. By 2020, you have Stanford Internet Observatory, which has launched a mass surveillance program on American speech on social media in close connection with federal officials, saying less than 1% of what we're seeing is foreign disinformation. What we're going after, it's all domestic, right? So going back to 2017, you have the separate pressure campaign, which is also punctuated by congressional hearings where they call in, Mark Zuckerberg and Sundar Pichai and then Jack Dorsey, and they berate them. And in
Sundar
public,
Pichai?
He was then the CEO of Google, may still be, which owns YouTube. So the big three in this space are Twitter, Facebook, and YouTube, but they're also very active on other platforms. In the big meetings, they have 8 platforms involved: Reddit, Wikimedia Foundation, Yahoo, which owns, I can't remember which platform they own, but there's a whole group. They're trying to reach every single platform, right? But there's special pressure on Facebook, Twitter, and YouTube. And again, those executives have been called in. Google, Mark Zuckerberg congressional testimony, and you get like 20 hits going back and forth. They kept making him come back in and testify, berating him in public, putting pressure on him. If you're in the C-suite of a major corporation, how do you react to that? Exactly as predicted. You do whatever you can to get them off your back, right? Especially if you're not getting pressure from the other side. Nobody's, the tiny little users whose First Amendment protected speech is being taken down don't have like a, organized lobby to go fight back against the power of big government. So what you end up is the platforms very quickly in the election space cooperating with this government pressure. And we got findings to that effect. That was an effective platform.
And Zuckerberg isn't going to take the little person's call either. He's going to come in front of Congress.
Or Dr. Fauci, as we see 13 times in 2020.
And they set up
in our evidence.
Yeah, and they set up special portals and special numbers for them. They had a direct line. The White House and other agencies had a direct line into these social media companies.
And one of the things that they do, and Zhonette, tell me, they said they were experts on what because one of the things that happened is some of the cases that failed are you sued Facebook or you sued Twitter for throwing you off, and they said, well, they're private parties and here's our terms of service. But the government they were doing something with term of service with these people.
Absolutely. The government would, on the border, what was borderline content, if it was content that didn't violate terms of service for a social media company and the government didn't like the content, they're like, well, you should just change your terms of service and then we can make it violate your policies. And then you can take it down and it's no longer borderline. And of course, we'll just keep moving that border. But that's one of the things, that's one of the reasons the judge has in this order that the government can't try to convince the social media companies to change their policies, the content moderation policies, because they've already tried to do it. They've already done it.
And that's why part of the media narrative is that, well, these are private companies. Why are you saying they're not? Well, here is if you go on the internet and you click that button and you don't read the whole mind-numbing thing, you now have your terms of service, but you can go back and follow it. You think it's between you and Zuckerberg's company, but the government has put clauses in, is what we're finding, right? So the government has become an active participant in contract formation, which is not, it strikes me, it doesn't make them a stranger to all these transactions.
That's exactly right. And we have really powerful findings on that. Fortunately for us, there was like a bunch of public statements to that effect in the election space coming out of the Election Integrity Partnership. They were super proud of what they did in the 2020 election. So they wrote a 292-page public report and analysis saying, here's what we did to get literally millions of American social media posts taken down. And in that report, they openly described the government as their, key stakeholder, their partners, our partners in government. So we now have a finding from a federal district judge saying, for example, CISA, the federal agency, Federal National Security Agency, right? Our national security apparatus was, quote, deeply intertwined with the Election Integrity Partnership, which had a team of 120 analysts with uniquely privileged access to, what people are posting on the platforms, reviewing them using probably what we think is artificial intelligence type algorithms to sift through hundreds of millions of social media posts in real time. So the EIP report for 4 months in 2020 says, we reviewed 859 million tweets. And we identified about 22 million of them as potentially problematic to be, piled into our tickets, and then they would take the narratives of the tickets and try and get entire narratives of 829,000 posts taken down at a single time. So I so fired up about that, I forgot what question we were talking about.
Well, I was talking about the government involvement because I'll ask this question, then I'll go on to sort of the media stories, so you know what I'm going to. But why is this injunction important?
This injunction is important for a whole host of reasons. Number one, it has brought a lot of attention to what's going on. Without people knowing what's going on, it's going to continue to go on. It's going to continue to incrementally grow into other subjects. So outside of the legal context, it's important for people to know what their government's doing. But in the legal context, it's important because the government doesn't understand or refuses to acknowledge what is coercion. Even now, the government argues, we're not coercing anybody.
This
we're
is in what they filed last night, right?
I just read it. In general, and throughout, their whole position is, look, we're just making suggestions. People are free to agree or disagree, take our suggestion or not. And so it's important, it was apparently important to explain to our government that when you have this volume and this tone and this sustained effort, that is coercion. You are threatening the livelihood, an existential threat to these companies. That's not mere government speech. That's coercion. That's state action.
Anything to add?
Yeah, just to point out that I'd say make 2 points in response to that. Well, one is, was it coercive? Was it coercive? Well, how did the platforms react? You see these like desperately scrambling messages, text messages and emails from Nick Clegg. Nick Clegg is the Senior Director of Global Affairs at Facebook. He is high in the Facebook C-suite.
He used to be a big British politician.
He was the equivalent of the Vice President of the United States in the United Kingdom. His prior job was Deputy Prime Minister of the United Kingdom, now the #1 government affairs guy at Facebook. And you see him texting, saying things like, we're essentially expressing desperation to get back in the White House's good graces. And you see a sense of collapse of resistance on a particular date, July 16th of 2021, where Facebook says, there's a message saying, we want to understand, quote, what the White House expects of us on misinformation going forward. So, was it coercive? Well, how did the platforms react? They collapsed under the pressure. They experienced it as coercion. You see panic at the C-suite of the most powerful companies in the world.
Because you have the President of the United States literally saying, you're killing people.
And at the end of a months-long pressure campaign interspersed with threats of serious legal consequences that are going to cost those companies potentially billions of dollars. I mean, that's coercion. The other point I would make is, imagine if the shoe was on the other foot and we had all these communications, but they were coming from the Trump administration. And the Trump administration was successfully getting the platforms to take down speech disfavoring the narratives that it liked. I think you would see hair on fire, screeching cries of fascism from the very quarters that are now saying, ho-hum, nothing to see here, we're just being persuasive.
And now I'll go to the media narrative, because I have been kind of shocked by it, even now, that they're saying, this is necessary. And part of me, Matt Taibbi goes on and he says that they always use the foreign influence or war or things like this, because those are the analogies, right? The State Department or the Army would call up the New York Times, don't release that story because we're going to lose agents. Let us get our agents out. So that happened a lot during the Cold War. There'd be something like that. And that's what they analogize this to. But they weren't doing that because of threats. They were doing that because they were Americans. And one of the things that really strikes me about this, because I had a very jaundiced view of all these platforms and who was making them up, they don't seem to want to do it, right? They make their money by doing it. It's not like they said, can we, we'd really like to do it. It's not like, hello, they got a phone call and they call up and they said, who else can we throw off? Can we throw off this guy? Can we throw off that guy? You know who I hate? This guy. I want to throw him off. Would that be good for the president? That's not what they're saying.
That's a great point. And actually, one of the really, really interesting findings in Judge Doty's order, because it is not what we advocated for, because I pushed as one alternative theory of state action is conspiracy. In other words, the government is conspiring with these platforms. But our evidence doesn't really indicate that. And that's what he found. He said, you know what? I do not find a conspiracy because it looks to me like they were forced to do it. They actually put up a resistance, right? Twitter did not meet with the White House on April 21st. And as we now know, have Andy Slavitz say, we think you should deplatform Alex Berenson immediately because he's the epicenter of disinformation rating out to the persuadable public. He's a key strategic speaker who criticizes our narrative. And Twitter's reaction was, he's not violating our terms of service. He's not saying anything false. I mean, he's saying truthful things and so we're not going to take him down. But when the pressure finally heated up, they caved. And so our judge looks at those facts and he says, I think the platforms are victims here. I don't see them, based on the evidence we've seen so far, as really in the co-conspirator bucket. I see them as people who were forced to do this by government pressure. And that's a fascinating reality.
And I wouldn't have thought that at the very beginning of this.
Me too. I would have thought that there was, if you'd asked me at the very beginning, are the platforms going to resist as much as they did? I'd have thought, no, they'll fall in the line right away with whatever the administration wants. And that's not, especially in the Facebook case, Facebook was like, really, they were advocating against. One of the things they said towards the very end, before the July, there's a big sea change. Facebook then after July is just like totally knuckled under and like sending them reports saying, we're going to take down this, we're going to take down this, please don't be mad at us. But up until then, very late in the day, they sent a really interesting email to the White House saying, you're telling us to take down all this misinformation, but the experts that we're talking to say censorship is going to harm your interests, because censorship is going to make people believe that the deck is rigged against them. And if you let the disfavored people speak and the favored people speak, people will come to the truth of the matter in the end. Facebook made that argument, right? And that made the government really mad. And almost immediately you have Jen Psaki saying, we favor a robust antitrust program. I may have the chronology out of line there, but almost immediately after that, you see a big ratcheting up of the pressure. Because that was also when they're saying, take down the disinformation doesn't. And Facebook's like, they don't violate our terms of service. A really interesting dynamic there, and not necessarily what I would have thought.
You were there when John was arguing the preliminary injunction, and there was something you told me about, and I think I saw it again, where the government says, well, they didn't knuckle under, right?
Yeah, the government's position was essentially, unless we break their will, it's not coercion. So up until that moment, we are only persuading them until we break their will. That was essentially their position.
And keep in mind, there's two standards. It's coercion or such significant encouragement that the decision has to be attributed to the government. Plus, there's two other legal standards that Judge Doty also found that we satisfy that don't require coercion at all. Joint participation and pervasive entwinement. Even if there wasn't a single threat, they were so insinuated into the decisions that we're making that it was really a joint government-private censorship decision-making process, and that makes it state action as well. And I don't think they have a good answer to that. I mean, the findings there are just astonishing. When you've got anyway, go ahead.
You are, and so, and there is, and I'll go back to how this stuff starts, because I did take the Crawford deposition, and it appears the Census Bureau first got these portals. And at least her testimony, I don't have any testimony that the Census Bureau asked stuff to be taken down. They said, how do we get out the message that people should fill out their census forms and they'll get, their benefits are that way and their voting rights are that way. And we want to make sure that gets out whenever people are saying something else. We want this to happen. And it may turn out that Census did more than that, but that's all the testimony is that I heard. And so then the CDC gets hold of these portals and they go hog wild, and COVID comes out, and this what looked like just, hey, look, how do I call your editors and tell them what message I would like people to hear? Which I don't think we'd be complaining about, right? If they said, here's what we want people to know the government's saying.
Still allowed under the injunction?
Still allowed under here. That's how it started, and then it's like those memes. How it started, how it is now, because then they just started pouring through the gap everything they wanted taken down. It was really amazing.
And in the early emails, you see Facebook saying to the government, "Look at all the stuff we're doing to, kind of accentuate your message. Look at all the stuff we're doing to sort of boost the government's message about COVID. And so we're doing such a great job on this." And the government's like, "No. We don't want you to just boost our message. We don't want the people who are disagreeing with us to be able to be heard." And so it's this notion that we're magnifying the voice of the government and the people, the experts think the governments are reliable. That was not good enough.
Right, and Crawford even said, I wanted the other messages downgraded.
Yes,
right?
That was a great admission.
So
questioning on that point by the attorneys.
It is amazing, and they don't seem to have any shame about it even now. I mean, we both scanned what they've just filed, and it's just like, this is outrageous.
They filed their opening brief in the Fifth Circuit last night, and the first paragraph, I think, is inflammatory, but essentially the government's position is it's our job to protect the weak and the ignorant, and we do that by controlling the narrative. That's essentially, they make other points that they've made all along the way about standing. They think that the states couldn't bring this lawsuit to begin with, or even our plaintiffs, that we didn't have a right to an injunction because we'd been harmed in the past, but not in the future.
Yeah, they want to do it. This is what an injunction has to be forward-looking. You enjoin action in the future, and they say, well, look, COVID's over. We're saying COVID's over. So since we're saying that, we won't do it again. But COVID could come back tomorrow if the CDC says it comes back. So I don't think these are going to be good. But John, why don't you tell us, where does the case stand right now, and what's next?
It's a great question. So the injunction was entered on July 4th, 2023, Independence Day, by Judge Doty. Don't know what his motivation was, but I thought it was awesome.
Happenstance. The grill was heating up, so he had time on his hands.
Right. So, well, you just enter a 155-page preliminary injunction against 6 federal government agencies in the White House. He entered that on July 4th, so there was an immediate appeal on July 5th. They filed a notice of appeal. They filed emergency stay motions pending appeal, which we've responded to, and they replied to 2 days ago. But what the motions panel did in the Fifth Circuit, and this is, quote, routine practice in the Fifth Circuit, is they granted, and I thought it was great for us, I thought it was a really good ruling. They granted a temporary administrative stay of the injunction, saying that's not in effect now, but instead of saying we're going to have litigation about stay motions, maybe stay it, maybe don't stay it, and then have briefing for 3 months and oral argument 5-6 months from now, they said we're giving you highly expedited consideration of the merits of the appeal of the preliminary injunction.
In the next panel we have sitting. So
next available panel, which turned out to be August 10th. So
right.
Yeah, and so we're on a hyper fast merits briefing schedule. The brief that was filed yesterday is the 65-page, 13,000-word merits brief, the government's merits brief challenging the preliminary injunction. We're now on the clock, so as soon as this is over, we're all going to race to our desks and start typing. But our brief is due a week from Friday, and then the government, that's the 4th, the government's got to turn around its reply by August 8th and oral argument on August 10th, which is what is that, 2 weeks from today? 2 weeks from tomorrow. So this is a highly expedited consideration by the Court of Appeals. What will happen after that? I had them do this in a similar case that I handled in the Missouri Attorney General's office. It was an immigration-related case. They had the opinion out in less than a month after the argument, so we could be, if they do that again, we could be looking at a merits decision on whether or not this injunction is being upheld by at least the panel of the Fifth Circuit in maybe by the end of August, maybe by the end of the summer. And then after that, whatever side doesn't prevail is probably go to the next step. You could go to the en-banc Fifth Circuit. You can go to the U.S. Supreme Court, both on stay motions and on the merits. If we win in the Fifth Circuit, I wouldn't be surprised if the government goes to the Supreme Court and says emergency stay motion and also grants cert before judgment. I guess it wouldn't be cert before judgment because they granted. Yeah.
And I think that's got to be it, because they've moved. I mean, not only the tenor of the things that they file, but the speed with which they file them. I mean, it's July 4th, out comes the order. It's 155 pages. In less than 24 hours, a motion to stay the injunction and then an appeal, right? And then immediately a motion to stay in the appeals court. And it's these are all in days. So the government wants to be doing something that it shouldn't be doing, is and they really, really want to be doing it.
Well, go ahead. Yeah.
No, I with the federal enterprise, they're probably already writing their brief for cert. They're probably already planning on what happens if they lose and how can they stop it immediately.
Exactly, and I always think of that. I thought it was a really telling moment at the oral argument in front of Judge Doty, where Judge Doty said, you could tell he was deeply troubled at that time by what the federal government had done here. And one of the things he asked the lawyers for DOJ was, he says, how can I be sure this isn't going to happen again, right? Because the question is, a preliminary injunction preserves the party's rights until the case is decided on the merits. So basically the standard is, for the pendency of the case, as we're litigating for another year or 2 years or whatever it is, how do we protect these people's rights? And he goes, how can I be sure this isn't going to happen again? And the DOJ attorney says, well, it isn't the government's position that this will never happen again. Right? That's there are 2 you-knows in there, right? But it isn't the government's position, that this will never happen again. That's a direct quote from the transcript. Because, of course, our position is this is all hunky-dory. It does not violate the First Amendment, and this is awesome. As you said, we're protecting the weak and the ignorant from, the best quote of all, probably, in all this is Jen Easterly, the director of CISA, who had an interview in 2021 or a public speech or something where she talks about our cognitive infrastructure. She says, we live in a world where people get to choose their own facts, and that's, really, really dangerous. If the American public gets to pick their own facts, she thinks, no, the government's got to be picking the facts, right? We can't let the public pick their own facts. And she says, we're really focused on our most important infrastructures, our cognitive infrastructure. What's our cognitive infrastructure? That's the thoughts inside your head. And Jen Easterly's view is our federal national security agency, our federal national security state needs to police what are the thoughts inside your head. And why does she call that infrastructure? Because it's in their agency name, the Cybersecurity and Infrastructure Security Agency. That gives her a mission to police truth. I mean, it really is, as Judge Doty found, it's Orwell. I mean, it's a ministry of truth. That's really what they're thinking is, we need to decide what the facts are. We can't let American advocates pick their own facts. And of course, this is all completely antithetical to the First Amendment's foundational principles.
Well, and their view of anyone who's weak and ignorant is anyone who disagrees with them.
Yes. Weak, ignorant people like Miranda Devine of the New York Post, who ran a story, or who was the reporter who's testifying last week in front of the House Judiciary Committee. No, it was the one who actually wrote the original fact story in the New York Post. This weak, ignorant person who had spent months researching and carefully sourced and confirmed the truth of her reporting. She's got to be protected from that, and many other things as well. Or weak, ignorant people like your clients, Stanford epidemiologist Jay Bhattacharya, or former director of the University of California at Irvine's bioethics system, Dr. Aaron Kheriaty, or Harvard scientist Dr. Martin Kulldorff. These ignorant, people who just happen to disagree with whatever the regime thinks is the truth of the day. Keeping in mind, of course, the truth of the day changes with dramatic speed. On masks, for example, Dr. Fauci's deposition, it was like, first he was for him, then he was against him, then he was for him, then he was against him. And the truth, how do the platforms keep up, right? Well, we have to take this down. I'm joking, right? But there is an element to it. The approved truth changes. It changes dramatically.
The thing that I was struck by this, we haven't done any of the laptop stuff or any of the voting stuff, but the New York Post is the oldest continuously published paper in the United States. It was founded by Alexander Hamilton. They have this researched piece, they published it, and then the platforms, no, you can't put it on. It really is something. So before we go to questions, I wanted to bring that up. I think, what do you hope is the lasting effect of this case?
Two things. On the legal side, I hope that the government comes to understand the limits of what it can do, the distinction between affirmatively endorsing a position and trying to control people who disagree with them. And the other thing that I hope is that people become widely aware of it. I saw on the street the other day a bumper sticker that said, "Make Orwell fiction again." Everybody should have that. Everybody should have that.
John, same question.
That's a great point. Here's my thinking on this. I hope our injunction will be upheld by the courts of appeals. I believe it will. I'm optimistic. In my heart of hearts, I think if serious federal judges look at this and say, oh, what the government did here is okay, and they can keep doing it, it doesn't violate the First Amendment, we have a huge problem in our republic. If we get to the Fifth Circuit in the Supreme Court and they say, this is okay, this doesn't violate the First Amendment. So I'm optimistic that will prevail on appeal, but even if we don't, publicizing this so the American public knows what's going on. And that's what one of the really good things about the discovery is we've been allowed to find out facts and make those facts public. And many of the kind of legacy media outlets have pretty much ignored it, right? And when they finally were forced to report on it, have put this positive spin on that. New York Times that wrote one article on this entire case up until, that I'm aware of, up until the injunction. And then when the injunction was issued, the spin was, federal court, limits government's ability to communicate with social media platforms about dangerous ideas. It was something like that. It was a total pro-government spin on it. And of course, you're talking about kind of legacy outlets who have something like I won't call it an oligopoly, but it's oligopolistic in the sense of its historic control of information, and you have an insurgency. The insurgency is the new technology of social media that lets the common man in the street hold a megaphone like never before. You couldn't have a post go viral when Alexander Hamilton was the Secretary of our Treasury, but now you can. And the Supreme Court had really powerful language to this effect in a 2017 decision talking about how this gives a common man the ability to speak. Well, it's in a sense, it's disappointing but unsurprising that kind of the legacy media outlets are like, this is a threat to them, right? It threatens the narratives that they're pushing because someone can slap something on Twitter that 1 million people read the next day, and it democratizes speech radically. That is a threat to very powerful interests, and I hope that shining a spotlight on what's actually happened here will deter it in the future. Whether or not we prevail on appeal or don't prevail on appeal, I believe that the fact that this has been exposed and is continuing to be exposed, and I hope will continue to be exposed in merits discovery. Keep in mind, we've only seen the tip of the iceberg in discovery. In merits discovery, that will have a powerful deterrent effect. And I'm hoping that some future administration at Meese will be like, hey, we ain't going to do this anymore. We're going to play fair from now on. We're going to push our message. Other people can criticize it. And I'm hoping that's where we evolve towards as a federal government.
Having faith in the people again.
Exactly.
Well, that would be good. And I thank you for those thoughts. I think we can move to questions. If anyone here has questions, just go ahead, and Michaela will bring over the microphone.
Let me say first, Mr. Sauer, it's been a privilege for NCLA to litigate this case alongside you. And,
likewise.
We can tell it's a passion project of yours, and it's been, thank God you're doing this work. So bless you for what you're doing, and please keep up the good work. A couple of times the Changizi case was mentioned, and I don't know if you can comment on this or not, but that case is currently pending in front of the Sixth Circuit. Oral argument's already been held, and as you know, the district court there didn't allow. Well, first of all, was the motion to dismiss was granted in the district court, and so now the question on appeal is, should the motion to dismiss be upheld on appeal? It seems to me that all of this discovery that's come out, all of the factual findings in Judge Dowdy's preliminary injunction order, I just can't imagine how the Sixth Circuit could uphold the district court judgment in the face of all of that. Do you have a prediction, or how do you look at that? Is it just too...
I don't know who your panel is, so I qualify that with I remember talking to Janine. I believe Janine argued that case. I remember talking to her. Oh, you argued.
I argued.
John argued. Well, I remember.
Yeah.
And I carefully read that district court opinion because it was a hurdle we were very well aware of when we were drafting the complaint in this case, and we wanted to make sure that our pleadings kind of, did whatever they could to get past what multiple. It wasn't just Changizi, because there was litigation. There was cases filed by President Trump against the social media platforms that got transferred to the Northern District of California and dismissed. There was litigation filed with Jed Rubenfeld, the Yale law professor, as one of their counsel, filed on behalf of Children's Health Defense. And those cases, I mean, these cases were 12B6. The only one that wasn't, interestingly, it was a senior district judge appointed by Ronald Reagan, very elderly judge, let Alex Berenson, who was case against Twitter, have a tiny bit of discovery, and all it was the communications that happened to mention Alex Berenson. And out of that, you got, there was a meeting with the White House where Andy Slavitt said, deplatform Alex Berenson now because he's the epicenter of disinfo that radiates out to the American public. I mean, so the tiny snapshots you're getting there were astonishing. I don't want to predict what will happen in the Sixth Circuit, but even if you get an adverse judgment from the Court of Appeals, I think it'd be a pretty powerful en banc petition, or a cert petition to the Supreme Court. Hey, for all we know, this case might be at the Supreme Court at some point. Hold our case for this, because, by the way, all those allegations we made in the Changizi complaint turned out to be the gospel truth, supported by overwhelming evidence. We now know that all this stuff that you said was implausible under Iqbal and Twombly is now supported by 6 sworn depositions of senior federal officials and 20,000 pages of emails. I like to think that case will come back to life. If it doesn't, I'm like, what's going on in the Sixth Circuit? I mean, so fingers crossed. I think you guys have a lot to do. I mean, even now, if suppose you got an adverse ruling today, you could file an en banc petition or a motion for panel reconsideration or both, saying, read this opinion, guys, out of the Western District of Louisiana.
Hopefully soon from the Fifth Circuit.
Right, yeah. And that, again, the Sixth Circuit panel may sit around and wait and see what the Fifth Circuit panel does in our case too, and that might inform how they decide that case. I mean, that's all speculation, but sometimes I think they do that. They kind of wait and see where other panels are going. So it's a great question.
I have not read the 155-page opinion by Judge Doty. Instead, I just read what the Washington Post has to say. I gathered, I never once heard them in any of their coverage dispute any of the factual findings by the district court. Instead, this is a terrible injunction. All the lawyers and experts we talk to think that it's way too broad, way too vague. Of course it will be overturned because it's suppressing government speech, and there's no way they can know how to comply with this injunction. So of course it has to be struck down. So I guess my general question to you is, what's your response to that? And secondly, would you consider this a victory if the Fifth Circuit said, we uphold all of the factual findings, but we remand to the district court for a more narrow injunction?
Or more narrow or more precise injunction. I think that would be a a victory. It's not the victory that I most prefer. Obviously, I'd like the injunction to be upheld. And I think the arguments that it's too vague are, frankly, pretty weak. There's a number of responses to that. One is when you're looking at an injunction that has broad language, the evidence that was presented to the court on which that broad language is based informs the meaning of that. And the government has very specific examples of its own misconduct going on for pages and pages and pages to inform that injunction. And also, what we see, and this is the point I made in the stay response, what we actually see is they spent months trying to come up with legitimate examples of legitimate government speech and legitimate government conduct that they say an injunction would interfere with, right? Because their whole strategy is to try, I mean, if you look at the big picture, they've suppressed literally millions of acts of expression by American citizens. And the district court found that again and again. The word million is in that opinion like 12 times, right? And so they spent months. They put 5 detailed affidavits from the FBI, from CISA, from the CDC, from the Surgeon General's office, and from at least one other agency saying, here's the parade of horribles, here's the stuff that we do. And if you enter an injunction against our communication social media platforms, we're not going to be able to do all this. And Judge Doty addressed that by providing 8 specific carve-outs, right? It totally took the wind out of the sails of that argument. It was very well done. So now their argument is, well, those carve-outs are a little too broad, so we're not sure what they mean. But here's a series of like 4 or 5 hypotheticals that we don't contend have ever happened in the history of the Republic, and no reason they are ever going to happen again. But if they did happen, we'd be confused, and therefore stay the entire injunction, because you weigh the hypothetical and speculative conjecture that there might be some application that puzzles a poor federal official at some point against the suppression of millions and millions of protected acts of First Amendment expression by coercive action and joint participation. And in the government's view, on that scale, it goes like this. It's kind of like in Monty Python when you weigh the witch against the duck, and the duck weighs more. I mean, that's the world we're in these kinds of arguments. I mean, that's our counter-argument. I probably won't use the Holy Grail example in the brief, but I mean, that's the kind of stuff we're dealing with. And they did have some arguments. They said, look, here's CISA. CISA says we talk to platforms frequently, and we say we've got malicious cyber activity, right? And they got this long declaration that defines the words malicious cyber activity. Here's what malicious cyber activity is. And that declaration says this is different than misinformation and disinformation, malinformation. And we warn the platforms about malicious cyber activity all the time, which is stuff like phishing and fraud and theft of credentials and all that, right? And so Judge Doty says, okay, he reads that declaration. He says, I've got to carve out. You're not enjoined from, talking to them about taking down malicious cyber activity. And they filed an emergency stay motion saying, this is so confusing. He uses vague terms like malicious cyber activity. I'm like, it's in your declaration, right? I mean, it's defined in your declaration in detail for like 20 paragraphs. I mean, that's the kind of argument you're dealing with. I mean, the vagueness argument is they're pushing that real hard because it is a very broad, it's a historic injunction. On the merits, I think it's poppycock, but we'll see. We'll see what the Court of Appeals does.
It's willful misunderstanding, and
exactly.
I always say about this about whether it's vague or not, because you got a 155-page opinion, you got all the things you can do, you got things you can't do, and they obviously want to do something else here. But I always think in the Washington Post, if the federal government said that they were going to do something to the Washington Post, if they didn't get to decide what letters to the editor the Washington Post put in and didn't put in, the screaming would be unbelievable. If just the letters of the editor were censored as badly as the social media was censored. But now they're like, oh, I don't know how the government's gonna live. It's unbelievable to me.
But to the point of your question, there are such vehement, strong, diametrically opposed opinions here, I think, because of the opinions of the role of government. I mean, the government takes this position that it is our mandate and our duty to curate the information that the American public receives, because there is false information out there. And so if you accept that narrative, whether you accept it truthfully or you accept it as a means to an end, then yes, the sky is falling if you cannot curate truth, and that's your obligation. But part of the reason that we exist, the New Civil Liberties Alliance and other organizations like us, is to point out that that is not liberty, that is not the idea that this country was founded on. And so it's a fundamental difference of what it is that government's to be doing and what limits it should have and the role that it performs.
And one kind of I think we're at a point of inflection as a culture and a society, American society, on the freedom of expression. Do we still believe in it? Because there's a very recent public opinion poll last week, I think, saying, for the first time, it shows a majority of Americans favoring the notion that the government should have a role in taking down false speech. Right, and there was a really strict partisan divide on that. The Republicans still heavily favored freedom of speech, but now large majorities of Democrats support the idea that the government has a role of censoring false ideas. But of course, who's deciding what's false there? The government. And the more that organizations like NCLA can do to fight back against that, both in the literal courts and the courts of public opinion, the more that specific detailed information is pushed out to public about what's really going on. I think the more the American public will kind of turn against that idea. But if we don't stand up and fight for the freedom of expression, if we as a society no longer believe in the First Amendment, our courts are going to slowly follow what our society believes, and it's going to erode our most fundamental liberty. So we got to fight in the court of public opinion as well as fighting in the actual courts.
This might be too far afield, but I just want to know if it was on your radar. When I look at what's going on with the World Health Organization this fall and next spring and their agenda, and I look at the various executive orders that have been released in the last 18 months, including one in the last 10 days that dealt with setting up some kind of office headed by two military persons, one who I think is also a doctor, that I think has to do with content. It's what you talked about, some kind of, it's a very short executive order. What concerns me is the carve-outs, and what I hear for you saying the government is arguing, is that they want to be able to continue to behave in ways that will implement that agenda, and the carve-outs need to be broad enough to include the things that are in that agenda, and specifically much broader than health, like including, it seems like a lot of emphasis now on climate, or just, so in connection with this lawsuit, is there any focus upon making these carve-outs narrow enough so that that sort of agenda would not be like also swept in now beyond medical or election?
My take on this is that first we've got to get the injunction approved, right? And then oftentimes you have fights over what they cover and what they don't cover, because the government is going to, at some point, come up with something that they say is covered by the injunction and that they want to do. And they'll either come back to have the injunction modified, or they won't, or will complain. So the first step is to make sure that the injunction holds. And then these factual things like I read a little bit about this. This would be the same sort of thing the CDC would do. Who would say what the standards are for this, that, or the other vaccine or other health thing, and then the CDC would implement it. It's not like who could immediately implement it. So I think it would be covered by this.
But also, I think that it's covered currently. If the injunction stands, the injunction isn't limited to health issues and election issues and the Hunter Biden laptop. The injunction says you shall not, government, oppress speech that is protected by the First Amendment via social media companies. And it doesn't have topical limitations. It has a couple of special carve-outs for election information and a few criminal activity, things that the government was particularly howling about. But what you're talking about would still be covered under the injunction. And as John's mentioned, as we go forward and we get discovery, we're not going to limit discovery to those 3 or so issues. Anytime the government's trying to oppress speech through social media companies, it's within the bounds of this lawsuit. Our clients and the states act not only as speakers and represent speakers, but listeners, the ability to obtain information. And so that's at issue in this lawsuit.
Blake?
One last question. This one comes from a couple of different people online have asked the same question. And that is, what are the ultimate remedies being sought here? Down the line, if we are 100% successful, are people going to jail? Is there a permanent injunction? Are people going to be pilloried, perhaps tarred, feathered? What's happening? What's the outcome we really want?
We talked about Alexander Hamilton. Is he one of the people putting in the question?
Actually, the tarred and feathered, that's John Vecchione on Twitter. So.
We're seeking only injunctive release in this case. So we've only sought injunctive relief, and one of the reasons is all of our defendants are federal officials and agencies, and that's the relief you can get in this kind of case against them, and we'll be happy if we get a permanent injunction. We'll be delighted. That's what we're going for. This is not a money damages case. So.
I agree with that. And with that, on behalf, I want to thank our panelists, but on behalf of the New Civil Liberties Alliance and our esteemed panel, I want to thank you all for attending this luncheon law event entitled What Missouri versus Biden Means for Free Speech. Be sure to join NCLA events coming up in the next month or two, including a CLE event discussing the impact of ESG policies, as well as a luncheon law event on yet another case involving the censorship industrial complex, in which people were injured by the vaccine but were censored when they tried to share their stories. Thank you very much, and please join me in thanking our panel for this valuable input.